Welcome back to our show. This is Higher Ground Financial Group. I am Daniel Rasby, a tax attorney, and here's my father, Imran Rasby. Raz.
Yeah, we're talking about risk, fees, and taxes. Riskfeestaxes.com. That's what this show's about, because those are things that are killers for your retirement, right? Those are leaks in your bucket of retirement money. Risk, fees, and taxes, all those things take money out. So besides that, what are the things that we should talk about? One of the things is, you know, planning for your legacy, right? If you're getting that age of retirement, you want to plan for your legacy. If I write a will on a napkin, I heard, Daniel, that I can just write a will on a napkin and that's good enough.
It actually would be valid in most states.
Really?
If you write a will on a napkin in the handwriting, as long as it's all handwritten, and even if you don't have any witnesses, it can still be a valid will.
Wow.
But is it good idea? Is it a good idea to do that? No, it's not usually a good idea to do that. You want to have as good of an estate plan as you can have to not only leave the legacy in the way that you want to the people that you want, but also help them inherit it with the least amount of hassle.
So there's really two types of estate planning we're talking about. One is if you have way too much money. I mean, not too much money, but more money than your estate exclusion is. The exclusion right now is 13.6 million per person, which is probably going to go down to about 6 million. We're not sure exactly, but it's going to go down. That's estate planning to minimize the estate taxes. But we're talking right now about a different type of estate planning, and we'll get back to the other type in a minute. But this type of estate planning is really
for everybody.
For everybody. Everybody should have that. Everybody, especially if you have real estate, right?
Yeah. So, most people know that you should have a will, and they may have heard about a trust, but you may not know why it makes sense to have a trust instead of just a will. And if you have real estate, a trust is very, very useful. In fact, it could be almost imperative to have a trust. And the reason is a trust bypasses probate. So first of all, let's go back to how does a will work? If you have a will, does the will make sure what you want is done? Well, it is your will, right? It is what you wish to happen, what you will to happen. But the court can make adjustments to it, especially if there is a lot of disputes. Everything is public about a will. That means when you die, all your friends and neighbors and enemies know exactly how much money you had and who it went to. And they all have the opportunity to dispute it and say that you owe them money or whatever and try to argue in court that it's a different amount.
Have you ever heard of scams against the elderly? Well, this is another scam against the elderly where, I could, if I minded to, I could look up obituaries and say, oh, Fred Jones just passed away and he had $3 million. Well, I can make a claim. I say, Fred Jones owes me $100,000 because I did some work on his house and he never paid me, and I'm going to tie up his estate for a long period of time.
So now his kids don't get any of that $3 million until they settle the claim that this fraudster is
right. And I could drag it out, and the kids might decide, you know what? It's only $100,000. We still get $2.9 million. Let's just pay him the $100,000 and be done with it, because I don't want to wait 2 more years before I get the money.
And even when there's nobody claiming against the estate, it can still take months or even years to go through a probate process. So it's generally better.
First of all, what is a probate process? What is that?
A probate process means it goes to court. When you die, it has to go to court. The court will open up a case about it, and they'll look for your will, and your kids will send that will to them if you have one. And if you don't have a will, the state will make a will for you. And depending on the state you're in, at the time of death, there's a different order.
And who inherits what?
Right. In some states, your spouse may not even get half of your assets, may only get a third of your assets if by default. So make sure that you have the will, but the probate process can still go and drag out a long time because
what they have to do is which goes to probate, they have to put advertisements in the paper and online to see if you owed anybody any money before you passed away, because they have to clear that estate out. Any money that's owed to somebody has to be paid first before your inheritors inherit their money.
And so with if you want to avoid probate, then you need to have a trust. A trust bypasses probate, and we can help set up a trust for you at my firm. We have Higher Ground Financial Group for the risk, fees, and taxes. And you can go to our website, riskfeestaxes.com, to talk to us and make an appointment. But I have a law firm as well, Higher Ground Legal, and we do help clients with estate planning all over the country. We do wills and trusts.
And there's lots of different kinds of trusts. You got to find the right kind of trust. But for this is a living trust. It's for husband and wife, or just if you're single, is one person. And what that does is it's a shadow, your shadow, while you're alive. So you're not giving up control of any of your assets.
It's revocable. It's a living, revocable trust. Revocable means you can make changes in the future.
Right. Because sometimes the word trust brings fear into the hearts of many people. Say, I don't want to give away all my assets. Then I don't have any control. But the living trust, you're not giving up any control at all. It's a revocable trust. It works as your shadow while you're alive. And then when you pass away, or if you're married, when your second spouse passes away, then and only then does it become irrevocable. So it becomes an entity on its own. And that's how it bypasses probate.
And so if you have your house inside of a trust, when you die, the probate court looks at it and says, oh, the owner of the property did not die. It's a trust. So there's nothing to go through probate. And so it's all private. It passes immediately. Your kids can inherit it right away. And so some people think, well, trust is still very complicated. Isn't there another way? Well, there is. Many states have something called a beneficiary deed.
Or TOD.
You can, a TOD deed, a transfer on death deed, where you can put your kids on as a beneficiary of your house. And when you die, they inherit it without a probate. So it still helps with the probate thing, but it does make it very difficult for them to now get rid of that property, because if you have 3 kids and they all go on the deed together, and then one of them wants to rent the house, one of them wants to sell it, the other one wants to move in, they're not agreeing on what to do, and they all have to agree before anything is done. So if you have a trust, the trust can dictate the house must be sold or the house may not be sold, and you can tell your kids ahead of time what should be done and what must be done, and they have to follow that.
And also, that doesn't take into account divorces or in-laws or grandkids. All those things come into play with the transfer and death deed. What if one of your children are going through a divorce at that time? Well, now it becomes an asset that's going to be split that you may not have wanted it to be split. So there's a lot of dangers when you try to go the cheap route. Go the cheap route, you end up costing you more money.
Right. So, speaking of that, you can download a free will or trust template online, or maybe you could pay $100 and have one done.
And there's many services out there that give it to free, or you pay a couple $100, you get a trust done. But is it really going to be in your best interest? No, because you have nobody to talk to, nobody to give you information and help.
And there's no legal advice that you're getting to find out, did you check all the boxes right? Did you miss something that is very important in the laws of your state?
And you got to retitle your house. Those things are not going to help you retitle the house into the trust, where Daniel's law firm will help retitle the house into the trust, or houses as it may be. So
it's very important to work with an attorney to set up your estate plan. If you have more than whatever the tiny estate limit is in
most states, it's $50,000. Not every state. Some states a little bit higher, some states less, but most states it's $50,000. And Daniel, you can do a trust in just Maryland, DC area,
or in California. We do it everywhere.
Okay,
we do in California and Florida and in Texas, and
so it doesn't matter where your property is. It doesn't matter where you live. You're dealing with.
Yep, we have licensed attorneys that work for our firm in every state, so that we're able to help our clients make sure they can get their wills and their trusts done.
And so what if I get a trust here in, say, the DC area, and I move to Florida? Is that trust still good?
Yeah, and most states have a law that says a trust done in one state is valid automatically in another state. Wherever you die is the law that's going to determine that. And some states have community property, like in California, you have community property, and that is dealt with a little bit differently. So sometimes it makes sense to do some edits or adjustments to your trust, but usually not a very big one if you end up moving into a different state. But we can help our clients with that. And when we do a trust, we stick with our clients for as long as they need us, and we can answer any questions as well in the future.
So riskfeestaxes.com to find out more about your situation, whether it's something you want to do or how you want to set it up. Riskfeestaxes.com. You can go to our website and make an appointment, and we'll help you determine what's best for you.
So what if you have a really great estate plan and you have a perfect will and perfect trust, everything's in place, but then you pass away and your wife and kids don't actually get the things that you thought they were going to get? What might have gone wrong? Well, maybe you had a beneficiary set the wrong way. Beneficiaries trump everything.
Yeah, we had that. Didn't you remember, Daniel? Just a little while ago, we had a client that got divorced 15 years prior, and he had paid out his ex-wife half of his 401k and half of his assets. He got married, had new kids and stuff, and now he was planning on retirement. And he sent the paperwork into you to review, and he really was sure that his ex-wife was out of his hair.
Yeah, but he still had her listed as beneficiary on his 401k. So that means when he dies, the other half is going to go to her.
plus
And
whatever it grew for the last 15 years.
and that is not what his plan was. In fact, he had a trust that said everything goes to his kids or his current wife or however he had it set up.
So even though the trust said that the 401k is going to go into the trust, that didn't matter because the beneficiary of the trust was not the beneficiary of the 401k was not the trust. The beneficiary was still the ex-wife.
And so beneficiaries trump everything. If you have an asset like a IRA or 401k or annuity or something that has a beneficiary on it, life insurance, make sure that the beneficiary matches what your estate plan is, because that's very, very important. So what you should get out of this is most people should not only have a will, but also a trust, especially if you own real estate, because real estate cannot really transfer by a beneficiary very smoothly. It has to go through a trust to be the most efficient. So most people are going to need a living revocable trust. And then you may need other types of trusts as well.
Yeah, we only have about a minute or two left on the segment, but we're going to talk a little bit about estate taxes, because if you have a lot of money and you're going to leave that to your kids, what happens if you have more than the estate tax deduction or exemption,
which in very short time is going to be around $6 million.
Then that means anything above that, 40% taxed. That's crazy. This is money you've already paid taxes on. This is money that you've gotten. You've already paid the government all this money, and now they want 40% of whatever you're going to leave.
Right. So then if that's going to apply to you, you want to take steps as soon as possible to minimize your estate taxes, and that might use some types of irrevocable trusts.
But dang, I don't want to lose control over that of my money.
If it's irrevocable, you don't have control, right?
Right.
Well, wrong. You actually might have some control, or maybe you could set it up so that your spouse has control, and then maybe you have control of her trust, and so it can be a lot of different ways to set it up so that you do still have some kind of control over the money.
So that's a spousal lifetime access trust that allows this spouse to have lifetime access on the money, and you don't, but that, again, you're married together. And then there's also intentionally defective trust that can help bypass some of those problems as well.
Yep, intentionally defective trust. There's ILITs, irrevocable life insurance trust.
And CRUTs, we talked about that before.
Yep, charitable remainder trust. There's a lot of different types of trusts. But if you own real estate, you do need a trust in most cases. So go to our website, riskfeestaxes.com, and we'll be happy to share with you, give you fiduciary advice on what is the best type of estate plan in your situation.
And having a special needs provision in the trust is always a good idea, because you never know what happens down the road.
Yes. So again, go to our website, riskfeestaxes.com, and we'll talk to you soon.